this is Angela, and you're listening to the Study for the Bar in Your Car podcast. So I'm back, and in the last episode, I'd mentioned that I was using Quimby Bar Prep, but I just wanted to clarify something about Quimby. And first of all, no one is paying me from Quimby to say any of this, but I did go over a few things that I liked about it, mostly that the lessons were short for the videos. But also they had this guarantee, like if you didn't pass the bar, then you would get your money back and you could go through the Quimby lessons again until you pass it. And I'm like, that's a good deal. And you know what? It definitely paid off for me because I did not pass the bar and I needed to take them again. And so with Barbary, they have, if you don't pass Barbary twice, then you're just done. But with Quimby, if you are a multi-time repeater like I am, you can keep using the lessons until you pass. And the other thing I really like about it, they have unlimited grading for essays, and I think that is pretty neat, like a real life person. I don't think it's AI at all. Not slamming an AI because AI is what makes this podcast possible. So I am a real human, but my co-hosts Maud and Claude aren't. They are these two AI bots. I've given them all my notes for civil procedure, and I've broken down everything into different topics. So you should know the whole spiel by now because this is the last episode within civil procedure. Well, we do have a bonus one after this, but this particular episode is a review of everything that was done between podcast number 2 or episode number 2 and episode number 8. So this is episode number 9, and it is a basic, rundown of what we've done. So we're closing it out here. So there's no new topics that we haven't been over. There's just a review of what we've done before. So then after this, there's the bonus episode. And I'm really excited about that because the bonus episode, I put an MEE question into AI and not an NCBE question, but I had it generate a specific question just for us, just so we could go over it and maybe sort of learn from that. So it might be great, it might be horrible, but I think it's going to be okay in the end. Anyhow, if you need to contact me, my email address is podcast@studyforthebarinyourcar.com. I also do legal work. I'm a law clerk. So if you are an attorney or you know an attorney who needs some legal help, they can count on me. You can email me for legal work at hello@legalwriterandlawclerk.com. Anyhow, so without further ado, let's bring it home for civil procedure. All right, Maud and Claude, here you go.
Welcome to the deep dive. Okay, so today we're doing something a bit different. We're calling it Study for the Bar in Your Car.
That's right. We're taking one last really comprehensive look at civil procedure. We're using Angela's notes and outline. She's an LMM student, and they're excellent.
Yeah, they really are. Think of this as our final word on Civ Pro for now. We want to help you nail this down before, you have to pivot to the next big bar subject.
Exactly. Our mission today, to really pull out the most crucial rules and concepts from Angela's work. We're hitting jurisdiction, venue, the law federal courts apply.
Pre-trial stuff, jury trials.
Right. Motions, verdicts, judgments, and appeals.
Yeah.
Basically everything you need for a solid Civ Pro foundation for the exam. Clarity and practical application. That's the goal.
Okay, let's get rolling. First stop, jurisdiction and venue. Where the lawsuit starts, essentially. Personal jurisdiction, that's about the court having power over the defendant, right?
Mm-hmm. It's fundamental. Angela's notes, referencing Rules 32 and 33, they really hammer home this idea of minimum contacts. The defendant needs a sufficient connection with the state, especially if the lawsuit is actually about those connections.
So it can't just be like accidental contact?
Generally, no. It's about purposeful availment.
Right.
Did the defendant deliberately engage with the state? Angela's notes mention targeting customers as a classic example. You have to reach out to the forum state somehow.
Got it. But then Angela's notes also mention the mere presence rule under Rule 32. What's that about?
Right. That's kind of the old school rule. If you properly serve the defendant, hand them the lawsuit papers while they're physically in the state, that usually works for personal jurisdiction.
Unless they were tricked into being there.
Exactly. Fraud or force would negate that. Now, Angela's outline also flags something called bulge jurisdiction in federal court. That sounds interesting.
It is, yeah. It's a bit niche, but important. It can extend the federal court's reach geographically, but only for parties joined later under specific rules, like necessary parties or impleader.
Okay, so not for the person originally sued.
Right, Angela's notes are clear on that, not for the original defendant. And a really key takeaway from Angela's Barbary materials. Federal courts usually analyze personal jurisdiction just like a state court in that same location would.
That makes sense. They're basically stepping into the state court's shoes for that analysis. And we should touch on general jurisdiction, too.
Right, where the defendant is at home.
Exactly. Angela's notes, citing minimum contacts part 1, point out that for a corporation, at home generally means where it's incorporated and its principal place of business.
And that principal place of business, that's the nerve center test from Hertz score.
You got it. Where the bosses direct everything. The corporate brain, essentially. Angela's notes flag that case.
Okay. And if someone doesn't have those kinds of contacts, Angela's outline mentions quasi in rem.
Yeah, that's based on property within the state. According to the Barbary outline Angela used, the lawsuit is sort of attached to that property. Less common now, but good to know it exists.
And finally, consent. Angela's notes mention form selection clauses in contracts.
Oh, definitely. Parties can just agree to jurisdiction and venue in a contract. That's a big one in practice.
Okay, shifting gears slightly. Subject matter jurisdiction. This is about the court's power over the type of case, right?
Precisely. Federal courts, as Angela's introduction to subject matter jurisdiction source notes, have limited jurisdiction. They can't hear just any old case.
And the two main ways into federal court, based on Angela's notes, diversity and federal question.
Those are the big ones. For diversity, Angela's Barbary notes stress 2 requirements. Complete diversity of citizenship.
Meaning no plaintiff from the same state as any defendant.
Right. And the amount in controversy has to exceed $75,000. Both have to be met.
And figuring out citizenship for corporations, Angela's notes say it's state of incorporation AND principal place of business, using that nerve center test again.
Correct, citing minimum contacts part 1. And for LLCs, Angela's separate E-001 source says you look at the citizenship of all its members. That can get complicated quickly.
Yeah, definitely. What about cases involving non-U.S. citizens, alienage jurisdiction?
Angela's Barbary notes cover that. You can have, say, citizens of different U.S. states suing an alien, or vice versa. But there's a specific restriction mentioned. If a permanent resident alien lives in the same U.S. state as an opposing party who is a U.S. citizen, that usually kills diversity.
Good to know. Okay, second gateway. Federal question jurisdiction.
Right. Cases arising under federal law, the Constitution, federal statutes, treaties. Angela's introduction to subject matter jurisdiction source lays this out.
And the main test is the creation test from the federal question jurisdiction source.
Yeah. Basically, did federal law create the cause of action? If yes, usually federal question jurisdiction. Angela's outline also mentions the embedded federal question idea.
That sounds trickier.
It is. It's when a state law claim fundamentally depends on resolving a really significant disputed issue of federal law, the complex multi-factor test.
Okay. Now, supplemental jurisdiction. What if you have one claim that gets you into federal court, but other related claims that don't?
That's where supplemental jurisdiction comes in, as Angela's outline explains. If the extra claims are so related to the main claim that they form part of the same case or controversy, the key phrase is common nucleus of operative fact, the federal court can usually hear them too.
Like they all stem from the same basic event.
Pretty much. But, and this is crucial, Angela's notes, referencing Rule 1367B and Barbary, highlight big limitations in diversity cases. You generally can't use supplemental jurisdiction to sneak in claims or parties that would estray the complete diversity required for the original claim. Think joinder under Rules 14, 19, 20, or intervention.
Gotcha. So it's not a total end run around diversity rules.
Definitely not. Okay, one more jurisdiction topic, removal.
This is when a case starts in state court but gets moved to federal court. Angela's outline says only defendants can do this.
Correct. And only if the case could have been brought in federal court originally. Usually all defendants have to agree, and there's a tight deadline, typically 30 days.
And a big catch for diversity cases.
Yes, Angela's notes flag this. If any defendant is a citizen of the state where the case was filed, you generally can't remove based on diversity. That's the in-state defendant rule.
And if a case is removed, where does it end up?
Venue is automatically proper in the federal district court that geographically covers the state court where the action was first filed. Angela's outline makes that clear.
Okay, perfect segue into venue itself. Assuming we're starting in federal court, where is venue proper?
Angela's Barbary outline gives us the main options. 1. Any district where any defendant resides, if all defendants live in the same state.
What if they live in different states?
Then you can't use that residency rule based on just one defendant. Option 2. A district where a substantial part of the events happened, or where the property involved is located. This is often the main one.
And if neither of those works?
Then option 3 kicks in.
Yeah.
Any district where any defendant is subject to personal jurisdiction. It's a fallback. Angela's notes also mention these rules cover all types of actions now, local or transitory.
What if venue is technically right, but really inconvenient? Can you move the case?
Yes, transfer of venue. Angela's outline mentions Rule 40. A court can transfer a case to another federal district where it could have been brought originally.
For convenience.
Exactly. Convenience of parties, witnesses, interest of justice. But Angela's notes remind us, the new district must also have personal jurisdiction over the defendants, subject matter jurisdiction, and be a proper venue itself.
And then there's forum nonconvenience, Rule 41.
Right. This is different from transfer. It's when the court dismisses the case, because the current forum is just seriously inconvenient, and there's a better forum available, often in a different court system entirely, maybe even a foreign country.
But harder to get if the plaintiff lives in the current forum.
Much harder, yeah. Angela's notes point that out. Plaintiff's choice of forum gets a lot of weight, especially if it's their home turf.
Okay, deep breath. That's jurisdiction and venue.
Yeah.
Now, what law do federal courts actually apply? This is the Erie doctrine, right?
Yeah, it's the heart of it, yeah. Angela's outline, referencing Rule 74 and Barbary, explains, in diversity cases, federal courts apply state substantive law. Think elements of a claim, statutes of limitations, burdens of proof.
But federal procedural law, like the federal rules of civil procedure.
Generally, yes. Federal procedure applies. The tricky part is when a state rule looks procedural, but actually functions substantively, meaning applying the federal rule instead would significantly change the outcome or encourage forum shopping. That's where Erie analysis gets complex.
So it's not always a bright line. Does federal common law ever come up?
Sometimes. Angela's outline notes that federal courts might create common law rules when there's a strong need for national uniformity or to fill gaps in federal statutes. It's relatively rare compared to applying state law in diversity cases, though.
And if a case involves multiple states, how does the federal court decide which state's substantive law to apply?
Good question. Angela's notes, citing Rule 73, say the federal court uses the choice of law rules of the state in which it sits. So a federal court in California, hearing a diversity case, would apply California's rules for deciding whether, say, California or Nevada law governs the substance of the dispute.
Okay, that makes sense. And the supremacy clause, how does that fit in?
Well, Angela's outline, citing Rules 70 and 71, reminds us that valid federal law trumps conflicting state law. So if there's a direct conflict between a federal rule of civil procedure and a state procedural rule, the federal rule usually wins, assuming it's valid.
Like that MEE question example Angela had about state rules limiting class actions.
Exactly. MEE Q03 from Feb 2021 showed that a state procedural rule trying to block class actions for statutory damages wouldn't stop a federal court from hearing that same state law claim as a class action, provided it met the federal requirements under Rule 23, federal procedure controlled.
Got it. Last point here, preclusion. What happens if a case or part of it has already been decided?
Preclusion doctrines claim preclusion and issue preclusion basically prevent relitigating things. Angela's outline, citing Rule 72, states that generally you look to the preclusion law of the jurisdiction that rendered the first judgment.
So federal courts respect state court judgments.
Absolutely. They have to give them full faith and credit, as Angela's notes mention, referencing the statute 28 U.S.C. section 1738. This means giving a state judgment the same preclusive effect it would have in that state's own courts.
And for diversity cases decided in federal court, what preclusion law applies later?
The Semtec case, which Angela's Rule 72 note cites, clarified this. Federal common law governs the preclusive effect of a federal diversity judgment, and that federal common law generally adopts the preclusion law of the state in which the federal court sat.
Okay, complex but crucial. Let's move into the pretrial phase. All the action before trial starts. Pleadings first.
Right. Federal courts use notice pleading, according to Angela's outline and Rule 12. The complaint just needs a short, plain statement of the claim, showing the plaintiff is entitled to relief, plus basis for jurisdiction and demand for judgment.
But it still needs some facts, right? Not just conclusions.
Definitely. Angela's notes emphasize it needs enough facts to make the claim plausible, not merely possible. That's the Twombly-Iqbal standard.
Okay. Then the defendant files an answer.
Yep. Angela's outline says the answer must respond to each allegation, admit, deny, or state lack of knowledge, and crucially, raise any affirmative defenses.
The statute of limitations or self-defense.
Exactly. Things that defeat the claim even if the allegations are true. And Angela's notes warn, failure to deny an allegation is generally treated as an admission.
What if you mess up your pleading or need to add something? Amendments.
Angela's outline covers this well. You get one amendment as of right early on within 21 days of serving it, or if a response is required, within 21 days after the response, or a Rule 12b motion is served.
And after that,
You need the other party's consent or the court's permission. But Angela's notes stress that courts should freely give leave when justice so requires. It's a liberal standard.
and amendments can relate back.
Sometimes, yes. Crucial for statute of limitations. Angela's notes explain it can relate back if the new claim arises from the same transaction or occurrence as the original, or if changing a tardy, the new party got notice within the service period and knew or should have known they were the intended defendant.
Okay. Rule 11, this sounds important. Preventing bad filings.
Very important. Angela's outline explains that signing a court document certifies, after reasonable inquiry, that it's not for an improper purpose, the legal claims are warranted, and the facts have, or will likely have, evidentiary support.
And sanctions are possible.
Yes. Angela's notes from MEDQ03 mention sanctions can hit attorneys, firms, or parties, though monetary sanctions for legally baseless claims usually target just the lawyers' firms. And there's that 21-day safe harbor period to withdraw or fix the filing after being challenged.
Good safety valve. All right, discovery. Getting information.
The big information exchange phase. Angela's outline notes it generally can't start until the parties have their Rule 26F meet and confer conference.
And initial disclosures happen automatically.
Angela's Barbary notes detail this. Certain core information like potential witnesses, relevant documents, damage calculations, insurance agreements must be disclosed early on without waiting for a request.
What's the general scope? What can you ask for?
Broad. Angela's outline and Barbary notes, citing Rule 26b1, say anything non-privileged that's relevant to a claim or defense and proportional to the needs of the case. Proportionality considers things like cost, importance, access to info. ESI electronic data is explicitly included.
Does it have to be admissible evidence?
Nope. Just reasonably calculated to lead to admissible evidence.
Okay, what are the main tools Angela's outline lists?
You've got interrogatories, written questions to parties answered under oath, requests for production, asking for documents, ESI, tangible things from parties or non-parties via subpoena, requests for admission, asking parties to admit certain facts are true, and depositions, oral questioning under oath.
Limits on depositions.
Generally 10 per side, 1 day of 7 hours each, unless the court orders otherwise. Angela's notes mention these basics.
What about stuff prepared for the lawsuit itself? Work product.
Right. Angela's outline explains work product materials prepared in anticipation of litigation gets protection. You generally can only get the other side's work product if you show substantial need and undue hardship.
And mental impressions are even more protected.
Yes, attorneys' thoughts, strategies, legal theories that gets almost absolute protection.
What if someone refuses to provide discovery?
Motion to compel, says Angela's outline. Ask the judge to order them to respond. Conversely, you can seek a protective order if the discovery request is, like, harassing or overly burdensome.
And sanctions for playing games.
Oh, yeah. Rule 37 allows for various sanctions for discovery abuse, including, as Angela's notes mention, paying costs if you improperly refuse to admit something under Rule 36.
Okay, Rule 16 conferences. Scheduling.
Crucial for case management. Angela's outline highlights the Rule 16b scheduling order. Early on, the judge sets deadlines for joinder, motions, discovery. That order controls the case timeline.
And later pretrial conferences.
Can happen to streamline trial, encourage settlement. Angela's Barbary notes mention the final pretrial conference order is key. It supersedes pleadings and maps out the trial.
What about motions before summary judgment? Judgment on the pleadings.
Angela's outline mentions that. After pleadings close, you can argue the pleadings themselves show you should win. Also, motion to strike to remove improper stuff from pleadings.
Okay, now the big one. Summary judgment, Rule 56.
A major hurdle. Angela's outline and Barbary notes define it. granted if there's no genuine dispute as to any material fact and the moving party is entitled to judgment as a matter of law.
Meaning no trial needed.
Exactly. The moving party argues the key facts aren't really contested, and based on those facts, the law dictates they win.
The other side has to fight back with evidence.
Yes. Angela's notes, Rules 1946, say the non-moving party must show specific evidence creating a genuine dispute. The court views evidence in their favor, but they can't just rest on their pleadings.
But not if witness credibility is the issue.
Right. Angela's notes, Rules 51 and 48, point out if a material fact turns on whose witness to believe, summary judgment is generally improper. That's for the fact finder at trial.
And denial isn't usually appealable right away.
Generally, no. Angela's Rule 77 note says, you wait for the final judgment. Also, Rule 85 allows a plaintiff to voluntarily dismiss before an answer or summary judgment motion is served.
Okay, let's say we get past summary judgment, jury trials. Is there always a right to one?
Not always. Angela's outlined, Rules 59-38 explains, the Seventh Amendment preserves the right mainly for suits at law, typically seeking money damages, not for purely equitable claims, like injunctions.
What if you have both?
Legal claims get tried by the jury first. Then the judge decides the equitable claims, bound by the jury's factual findings on common issues.
How do you ask for a jury?
You have to demand it. Angela's outline, Rule 38B, says within 14 days after the last pleading on that issue is served. Put it in your pleading or file a separate demand. Can't withdraw it without everyone's consent.
Jury selection voir dire. What happened?
Questioning potential jurors. Angela's outline mentions challenges for cause, bias, and peremptory challenges. Limited number, no reason needed, but subject to Batson challenges against discrimination based on race or gender.
How many jurors? And does the verdict have to be unanimous?
Federal civil juries start with 6 to 12 members. Unless parties stipulate otherwise, the verdict must be unanimous and returned by at least 6 jurors per Angela's notes. You can ask to poll the jurors afterward.
Jury instructions. The judge tells them the law.
Exactly. Parties propose instructions. Crucially, Angela's Rule 65 note emphasizes, object to instructions before the jury retires, stating the grounds clearly to preserve the issue for appeal.
Otherwise, you're stuck with plain error review.
Pretty much. Angela's notes, Rule 66, 67, 68 mention plain error is a tough standard only for really obvious, serious errors affecting substantial rights.
And verdicts can be general or special.
Right. General verdict. Jury just says who wins and damages. Special verdict. Jury answers specific factual questions. Judge applies the law. Angela's outline mentions both.
All right. During and after trial. Judgment as a matter of law. JMO.
It's also called directed verdict. Angela's outline, Rules 52, 49, 54, explains you can move for this after the other side presents their case, arguing no reasonable jury could find for them based on the evidence presented. Evidence viewed favorable to the non-movement.
And if the judge denies it and the jury finds against you anyway?
Then you file a renewed JMOL, RJMOL, formerly JNOV. Angela's outline, Rules 52, 53, says you can only do this if you made the initial JMOL motion earlier. Same standard. Could a reasonable jury have reached this verdict? File within 28 days of judgment.
What about asking for a whole new trial?
Motion for a new trial. Angela's notes say you often file this with RJMOL, also within 28 days. Grounds include trial errors, new evidence, misconduct, or verdict against the great weight of the evidence, a less demanding standard than JMOL.
Judge can order one too.
Yes, sua sponte, for prejudicial error, according to Angela's Rule 80 note.
What if you find out way later there was a mistake or fraud? Relief from judgment.
Rule 60. Angela's outline covers this. Clerical errors, Rule 60A, can be fixed anytime. Other grounds like mistake, new evidence, fraud, void judgment, like from bad service, as Angela's notes mention, satisfied judgment, or any other reason justifying relief have time limits usually within a year for mistake, fraud, new evidence, or a reasonable time for void satisfied at other.
Default judgment again if a defendant just ghosts.
Clerk enters default first. Defendant admits liability by failing to appear, but plaintiff still needs to prove damages to get a default judgment from the judge. Angela's notes, Rule 5584, stress proper service and notice are required.
Dismissals. Plaintiff can just walk away.
Sometimes. Voluntary dismissal before answer summary judgment is usually allowed once without prejudice, can refile. Second time is usually with prejudice, can't refile. Angela's Rule 85 note covers this, or parties can stipulate.
And involuntary dismissal.
If plaintiff fails to prosecute or violates rule sorters. But Angela's Rule 41B note is key. Dismissals for lack of jurisdiction, venue, or failure to join indispensable party are not on the merits. They don't preclude refiling somewhere proper. Dismissal for failure to state a claim can be on the merits.
Offer of judgment, Rule 68.
Yep. Angela's Barbary notes detail this settlement tool. Defendant makes a formal offer. If plaintiff rejects it and gets a less favorable judgment later, plaintiff might have to pay defendant's post-offer costs. Creates pressure to settle.
Okay, final stretch. Appeals, the basic rule.
Final judgment rule. Angela's outline, Rule 76, is clear. Generally, you can only appeal after the trial court issues a final judgment resolving all claims for all parties. Prevents constant interruption.
But there are exceptions. Interlocutory appeals.
Yes, important ones. Angela's outline lists orders about injunctions, class certification orders, Rule 23F, and certain collateral orders, important issues separate from the merits that would be lost if appeal waited.
What about denying dismissal for lack of personal jurisdiction?
Generally not immediately appealable per Angela's Rule 78 note. You usually have to wait until the end. Partial summary judgment might be appealable if the court certifies it under Rule 54B, finding no just reason for delay.
When the appeal court reviews, what standards do they use?
Depends on the issue. Angela's outline breaks it down. Questions of law get de novo review, no deference. Judges' findings of fact get clear error review, overturned only if definitely mistaken. Discretionary rulings, like evidence, get abuse of discretion review. Was the decision unreasonable?
And RJOL decisions.
De novo. Appellate court applies the same reasonable jury standard.
What about plain error again, for things not objected to?
Appellate courts can review unpreserved errors, but only if they're obvious, affect substantial rights, and seriously impact fairness. Angela's notes, Rules 65, 66, 68, reiterate it's a high bar. You really need to object at trial.
Preservation is key then.
Absolutely. Timely, specific objections are crucial, as Angela's Rule 67 note on jury instructions highlights. Otherwise, you're likely stuck hoping for plain error review, which is rarely granted.
Wow. Okay. That was a whirlwind tour, but hopefully super helpful. We hit jurisdiction, venue, applicable law, pretrial, trials, motions, judgments, appeals, all the big Civ Pro buckets drawing from Angela's great notes.
Yeah, a real deep dive. The goal was to give you, Angela, and everyone listening, a solid final overview to build on as you head towards the bar exam. You should feel more comfortable tackling those Civ Pro questions now.
Definitely. Hopefully this helps you put Civ Pro to bed, mentally at least, and feel ready for the next subject. It's all interconnected, though.
That's a great point to end on. As you move forward, think about how these procedural rules we just covered really provide the framework for almost every legal dispute. How might understanding these fundamentals give you an edge, not just on the bar, but in thinking about how law actually works in practice? Something to chew on.
Hey, I'm back. This is Angela, your living, breathing, not AI podcaster. So yeah, we're wrapping up civil procedure. The next episode is a bonus episode where we go over a civil procedure MEE question. Anyhow, if you need to get in touch with me, you can reach me at podcaster@studyforthebarinyourcar.com. Or if you need me to do any legal work, because I work for attorneys and I can do motions, writs, lots of stuff. So if you are an attorney or you know an attorney who needs some legal help, they can reach me at hello@legalwriterandlawclerk.com. Just a few reminders. I'm a law student just like you. I'm not barred by the state and I'm not giving any legal advice. 2, AI is sometimes not correct. So if I find anything that's not correct, I try to correct it, but I can only correct it to my capabilities and my own knowledge. So if something's wrong, just let me know, but please don't be mad at me if it is. I try to do my best to fix everything. Lastly, be safe while you're driving. If any of civil procedure or any bar topics are going to distract you from driving, you might want to pull over or you might want to hit pause. So hopefully you can do both at the same time. You know, civil procedure is just like walking and chewing gum, right? Anyhow, so glad we're done with this topic. After the bonus episode, we are moving on next to contracts. Yay! All right, thanks for tuning in, and I'll see you on the bonus episode.